Yeah, that's not helping.
Let's try again.
There we go. Thank you. Well, good evening. My name is Jeff Rabin, and I am an attorney, and all I do in my law practice is help people with disabilities who are trying to get benefits from the Social Security Administration, either SSDI or SSI. I became a lawyer in 1980 and started out with a small general practice firm downtown where I got stuck with the Social Security cases because no one else in that business wanted to either deal with this clientele or deal with this bureaucracy. As time went on, I found I liked the clientele and I liked the bureaucracy a whole lot more than I like other lawyers. And the nice thing about my work is I don't have to deal with other lawyers. It's me, the client, the judge, and off we go. I did my first disability case in 1981. I set up my own law firm in 1988 to do nothing but disability work. I've represented people all over the United States. I've given talks like this to groups all over the United States. I am a past chairperson of the Chicago Bar Association Social Security Disability Committee. I helped create the Disability Committee for what used to be called the American Trial Lawyers Association. I've testified before Congress on these issues, and I was even a bad guy on a 60 Minutes episode a number of years ago because I believe people with substance abuse deserve help. Lesley Stahl didn't, and we went at it, and she featured me as the evil lawyer helping people get SSI. So be it. So this is my thing. And I really appreciate coming here tonight. This is an amazing place. And Sabina and Lisa just do an incredible job. Nobody has a family that hasn't been touched by cancer and needs the programs that are offered here. So I really appreciate the opportunity to come back. So here's what we're going to do tonight. We're going to talk about the law. What does it mean to be totally disabled? What does that phrase actually mean? We're going to talk about the programs. There's SSDI, SSI, and the differences, because understanding those differences can be very important in your family planning. We're going to talk about how Social Security thinks about cases, because they do think about every case. They just often do it wrong. But we're going to go through their process, and we're going to focus, obviously, on how they handle cancer cases, because some cancer cases are very routine. They're handled very quickly at Social Security, because they recognize the severity, and some aren't. We're going to go through all that. We're going to talk about how to apply and appeal and move cases along. And then if we have time, and I hope we do, we're going to talk about the most important part of the program, which is how to go back to work on Social Security. You see, Social Security was never intended to support anybody. When it started as a program for our seniors, it was meant just to supplement private savings and family support. The way I view disability for many people, not all clients, because it isn't true in all cases, but for many people, we view Social Security disability as a time program, giving you some basic financial basis, and then time to treat, time to recover, time to retrain, and then time to return to work. And there's really good return to work systems built into the law, but they are confusing and they're scary. After we're done tonight, they won't be confusing. Well, they may still be confusing, but they won't be scary. Okay? Before we get into substance, let's just talk about where we're at with Social Security. After the pandemic, things really turned upside down, and we are still about 500 adjudicators short in our region. So cases at initial application and reconsideration are just stuck. It can take up to 240 days right now, 8 months, before Social Security even picks up or looks at the first time at a new application. They're aware of this. They're trying to solve that problem. It takes 2 years to train a new adjudicator, and many of the adjudicators that had their time in retired at the time of the pandemic because the movement from office to home was not handled very well. So we are still trying to fight our way through that backlog at the initial and reconsideration levels. Now, the administrative law judge hearings, though, have actually become much more or become much less backlogged. And we get hearings very quickly now because the hearings have moved from solely in person to having 3 options. You do it on Microsoft Teams video, or on the telephone, or in person. And most are doing it on Microsoft Teams or on the telephone, and that's helped reduce the backlog there. So cases still take a long time, but now it's because the backlog's at a different level of the process. Sadly, we had a wonderful commissioner for the last year, Michael O'Malley, who instantly came in and made a lot of significant changes in the Social Security system. But the politics being what it is, in a new administration, he has tendered his resignation. I read today that a new person has been nominated to be the commissioner of Social Security. He's the president of, no, I'm not sure where he was. I forgot. But I don't know anything about him. We'll see what he does. But Michael O'Malley was really truly devoted to the people of the United States in this role and to the Social Security system, and did a really, really good job. Last point here, after the pandemic, the district offices did open, but they're not fully staffed. And I really recommend, if you need to go there, try to make an appointment if you can, because you might be sitting there a really long time. If you just walk in, you will be seen, but it'll take a while. Okay, let's get into more substance. In order for me to get somebody disability benefits under the Social Security Act, either SSDI or SSI, I've got to prove the existence of permanent physical and mental impairment producing some severe preclusive ability to form a substantial gainful activity for a period that's less respect the last 12 months or result in death. And I always say it real fast because that's a lot of legal mumbo jumbo. So let's talk about what it really means. In order, excuse me, Lisa was going to write that down. This is what the law says. So let's talk about what it really means. In order for me to get somebody benefits, I have to be able to prove that they are suffering from symptoms which so impact their day-to-day functioning that they could not perform any type of full-time work available in the national economy for a period that has lasted or expected to last 12 months or result in death in 12 months. Social Security is not focused on the diagnosis. They do not deny that you have cancer. They do not deny that you've had a back fusion. They do not deny that you have lupus. That's almost never the fight. The focus in a disability case are on the symptoms from that medical diagnosis and how those symptoms impact your daily functioning. I get calls all day from people who say, Mr. Rabin, I have sugar, diabetes, and high blood pressure, and I want to get SSI. And my response is almost always the same. It's, gosh, those are really serious medical problems. My father actually passed away from untreated hypertension, but take your medicine, watch your diet, get a little bit of exercise, and go get a job. Because generally, those conditions do not produce symptoms that make it impossible to sit at a desk and answer telephones. If somebody calls me up and they have a physical medical problem, a bad heart, a bad shoulder, a bad back, my questions are always the same. What are the symptoms of that physical medical problem? And how do they impact your ability to sit in a chair, stand? I was going to pace, but Savina told me I can't get out of the camera. Walk, lift, reach, push, pull. Those physical motions that are involved in every single job, how are they impacted by the symptoms from whatever that physical medical problem? If somebody comes to me and they have a mental impairment, major depressive disorder, anxiety disorder, PTSD, agoraphobia. A new client yesterday's got attachment disorder to her mother, and it's bad. What are the symptoms of that mental impairment? And how do those symptoms impact this person's ability to do the mental motions of work? Understanding and remembering simple instructions, interacting appropriately with supervisors or coworkers, dealing with work change or work stress. Those basic mental motions that are involved in every job, how are they impacted by the symptoms of whatever label the psychiatrist put on this person? See, like I said, Social Security isn't going to deny the diagnosis. If a guy's got a scar 6 inches down the middle of his back, he had a back fusion. Social Security is not going to say he didn't. What they're going to say is, so what? What are his symptoms and what can he still do on a sustained basis in a work setting despite those medical problems. And they call that your residual functional capacity to perform work-related activities, RFC. What is the most that you can do in a work setting despite your medical symptoms? And they develop an RFC for every single person that applies. In fact, by the time we go to a hearing, there may be 4 or 5 different RFCs that Social Security has developed as additional medical records come in. And then they take that RFC and they apply it to the mythical world of work. See, this is not a reality-based program. And that's where working with people like Savina or Elisa becomes frustrating, because they know that guy with cancer in Waukegan is not going to take a job in Joliet, but that's not the issue. They will not focus on whether you could get a job or whether you know how to do the job or what the job pays, especially for people under 50, slightly at 55 or 60. But generally, those real world problems are not a factor at Social Security. Their only focus is on whether we can prove you cannot function at a job. So let's take an example. 49-year-old guy, this was an actual client. 49-year-old guy comes to my office. He's a union carpenter in Chicago. At that time, he was making $43 an hour plus benefits. He's climbing a scaffold tips. He lands on the ground. He herniates 2 discs in his lumbar spine, fractures a vertebrae. He needs a lumbar fusion. He's never going to be a $43 an hour carpenter again, because it's very unlikely that he's going to be able to bend and saw all day or carry 2x4s and climb at the same time. That's not the test. To get disability for this man, I have to be able to prove that he could not function full-time at a job like ticket taker at a movie theater. Sit in a chair, you can stand when you want, you rip the tickets in half, and Moana 2 is just down the hall. And I know about Moana 2 because I took my grandkids there this weekend. Ticket taker at a movie theater, coin changer at a self-service gas station, shoebox packer in a shoe store, washing machine unloader in a laundromat. These are all jobs that Social Security has used to deny my clients benefits in the past. A number of years ago, I represented a lady who had been a cardiac intensive care nurse here in Chicago, zapping people and saving lives. We see that on TV. And she developed rheumatoid arthritis. And this was before the biologics, so she ended up with 2 claw hands. Social Security denied her application, saying that she had the RFC to be a bicycle rental clerk. Back in the day, I told you I used to work with substance abusers, and I was representing a man who was living in Gateway Foundation's Kedzie House. And at that time, Gateway Foundation's Kedzie House was a 1-year lockdown program. You go in, you don't come out for a year, learning new methods of life, new ways to think and be. They denied his application, saying that he retained the RFC to be a bank vault security guard. Now, when I told Henry, the heroin addict, they wanted him to guard the bank vault, he said, "Mr. Rabin, get me the job. I wish. The point is, Henry would never get hired by the bank, and my nurse was never going to go rent bicycles. But that's not the test. The test was whether I could prove they could not function at those kind of jobs. If I did, I won. If I didn't, I lost. If you want to write down one word and you go to page 5 and you see a photo, a picture of whoops, I forgot to go there here. Desk that looks like mine and makes poor Courtney cry when she comes into the office. The one word you can write down that summarizes everything we've talked about now until now is the word do. D-O. Social Security is not concerned with your diagnosis. They're concerned with what you can do despite the diagnosis. Now, the one difference in that is the issue of cancer cases, because there are a number of cancers, and we'll talk about this, where Social Security will immediately admit you cannot do a job for at least a year. They're called compassionate allowances, and the analysis is a lot simpler, and we'll get into that in just a moment. But I didn't want to leave it out there without touching on that. Okay, so this basic law, proving the inability to function at a job for at least 12 months or with a condition resulting in death in 12 months, applies to two different programs. The first program is called Title II of the Social Security Act, Social Security Disability Insurance Benefits, SSDI, Workers' Disability, Regular Disability. We're going to call it SSDI tonight. The second program is called Title 16 of the Social Security Act, or Supplemental Security Income, or SSI. We're going to call it SSI. So we have SSDI, SSI. We're going to talk about SSDI first because it's the more comprehensive of the programs. To qualify for SSDI, you must meet a two-part FICA test. Number one, you must have worked and paid FICA taxes for at least 40 quarters in your lifetime. Number two, you must have worked and paid FICA taxes for at least 5 of the 10 years prior to the year that you became totally disabled. Their lingo is 20 quarters of the 40 quarters preceding the onset of disability. Let's take an example. I become totally disabled today. I would contact Social Security and say, I tripped and fell outside the Cancer Wellness Center. I'm a klutz and I banged my head and they rushed me over to Highland Park Hospital. And it turns out I have a concussion or a bad brain problem and I can't work. The first thing they would do is pull my earnings record and see if I've worked at least 40 quarters in my lifetime. I've checked my own earnings record, and I'll tell you all later how to check yours. I've got way over 40 years, so that one's easily met. Then they say, pull Jeff's earnings records from 2013 to 2023, the 10 years prior to the year I became totally disabled, and did I work at least 20 quarters during that time? If I only worked for 18 quarters or for 3 years, or I worked for cash and never paid the man a dime, I'll have screwed myself because I wouldn't have purchased the insurance. Social Security Disability Insurance. It is an insurance plan, just like your car insurance and your homeowner's insurance and your health insurance, except you pay for this by working and having your FICA taxes deducted from your paycheck. If I'm totally disabled and I've paid my FICA taxes, because being totally disabled is the second test, I will be eligible for a monthly check under the SSDI program. The amount of that check is a computer formula based upon how many years I've worked and how much I've paid into the system. The average person on SSDI is supporting their family on about $1,600 a month. So nobody gets rich or comfortable living on SSDI. My kids would get benefits up until age 16 or 18 and they graduate high school. I become eligible for Medicare, the federal red, white, and blue card, 29 months from the date I became totally disabled. Now, this is said lots of different ways on the street, and many of them are wrong. So let me go do this real quick. If I become disabled today, it's December of 2024, I would not get a benefit for the first 5 months. Social Security calls it an elimination period. We call it a starvation period. So I would not get a check for January, February, March, April, May. My first check on the SSDI program will be June 2025. Medicare kicks in June 2027. 2 years, 5 months from the date I became totally disabled, 29 months. There's 2 exceptions. If you have Lou Gehrig's disease or on kidney dialysis, you get your Medicare immediately. Actually, this angers me. There's no reason for this. Everybody should get their Medicare insurance when they're totally disabled and can't work. And the only reason these other 2 groups get it is there was an interested senator or congressman who knew somebody or had a family member, so he slid it into a bill. This is something that I hope the American Cancer Society and other agencies, the one that I'm involved with, the National Alliance on Mental Illness, I hope everybody is working on this to try to get this 29-month waiting period eliminated. So that's the highlights of the SSDI program. Totally disabled, worked and paid FICA taxes, you get a monthly benefit. Let's go to the next page. Let's talk about SSI. So SSI started in 1972 as a result of pictorial articles in Look and Life magazine talking about depicting, they didn't talk, they were all by photograph, the different living conditions between the elderly poor in the north who were getting some help from their states and counties and townships, and the elderly poor in the south who were not and were shown living in shanties and lean-tos and literally using cat food tins for plates and saucers. Congress thought our elderly poor using cat food tins was a bad idea, so they enacted SSI to help the elderly poor and then expanded it to help the disabled poor. So SSI has two requirements. First, you have to be totally disabled, the exact same medical test we talked about at the beginning. Second, you must be indigent. Now, indigent for this purpose means less than $2,000 in any kind of asset other than your house, if you're living in it, and one car, and you're also allowed a burial plot, and no money coming into the household. They won't value your clothes, they won't value your furniture, but they'll look inside your purse. Not literally, it's figuratively. They'll look for checking accounts, savings accounts, IRAs, 401ks, 203Bs, cash value life insurance, US savings bonds, poorly drafted family trusts, investment properties, anything that can be turned into cash, even if you have to pay a tax and a penalty to access it, counts against the $2,000 limitation. So this is a program for people who are permanently and totally disabled and very, very poor. If you qualify on these two requirements, you're eligible for SSI, and if you're living independently, next year, beginning in 2025, you will get $967 a month to live on, plus food stamps and a Medicaid card. Now, this is a program that a large part of Congress hates because SSDI comes out of trust funds. You've all heard about this in the paper. The trust funds are what hold our FICA taxes and the boss who matches our FICA taxes for retirement, disability, and Medicare. SSI is paid out of general revenue. So if your focus is on building more bombers or building more highways or simply cutting the budget for the sake of cutting the budget, SSI is a program that they always look at because it's paid out of general revenues and not out of the trust funds. There's a huge issue with SSI. And I'm going to spend a minute and go through this with you all. Remember now, I'm one lawyer. My office is in Mount Prospect, but I've had a couple in the area. And I'm one guy in this little corner of Illinois. I would estimate that at least once a week and often more for the last 35 years, I've had this problem come up. And then it could be guys or women, but I'm going to use a woman for this example. She graduates college 1999, has a good job, and she's making some money. She meets Mr. Wonderful. Now, Mr. Wonderful, he's working in a new tech company, and that company is soaring, and it goes public, and he gets options and warrants and all these things I don't even understand. And she says, I'm blessed. I'm able to make a choice because he's doing so well. I want to be a stay-at-home mom and raise my children. 1, 2, 3 girls. We go in 2008. That company has a problem because the whole economy tanked. He loses that job. He goes to another company. That company loses its patent. And now we're in 2024, going into 25, and he's working for a 6-man consulting firm in Skokie. Meanwhile, as these kids have grown, the oldest one's 23. She graduated college. Middle girl's 21, she's a senior. Baby's 19, she's a freshman. Mom is 48 years old, and she's taking care of all these kids. Now, working with this small consulting firm, they don't pay for family group health insurance. They insure him, but they don't pay for the family. That's up to him to pay. They're looking at 3 kids in college and saying, we can't afford college and these health insurance premiums. You're healthy, Mom. You can just, we'll manage. Happens every day, especially since they modified the Affordable Care Act a number of years ago to take away the mandatory health insurance requirement. Mom's 48 and she's hit by a car, or she develops breast cancer, or she's diagnosed with multiple sclerosis. And this is a real common time for MS diagnosis, so we'll use that. She comes to me and says, Jeff, I'm diagnosed with multiple sclerosis. Please get me SSDI and Medicare insurance so that I can afford the treatment to avoid ending up in having to use a stroller or a, Jeff, come on, a mechanized wheelchair. Can't think of the word I'm looking for. I have to tell her, no, I cannot get you SSDI. Why? She's not worked 5 out of the last 10 years at jobs that pay FICA taxes because she was home raising that girl, those girls, and that's not considered work in our system. Then she says, okay, I get it. Get me SSI, because with SSI I get Medicaid. Medicaid will pay for Avonex. That's the entry-level drug to keep me from losing use of my legs. And I have to tell her, no, you can't get SSI. Why? Because her husband's assets and income are deemed to her. Deeming says what belongs to me belongs to my wife, Sherry. What belongs to Sherry belongs to me. What belongs to the 2 of us would belong to minor children if we still had them. So she cannot get SSI. The rule in the United States is stay-at-home moms that get sick get screwed. It's just the reality of what happens. And like I said, at least once a week, often more than that, for 35 years, I've had to deal with that issue with somebody. It's really a serious hole in the law. Just real quickly, there's a part 2 of the story. Husband looks at her and says, you're sick. You're not fun anymore. And he's out the door. They're divorced. A huge percentage of my clients are divorced because of the stress medical issues and symptoms placed on the family. So she hires a good attorney, and they go through the divorce, and she gets 50% of what he had. And he had $250,000 in IRAs and 401ks from all these big jobs. She still can't get SSI because that $125,000 in 401ks, even though it's meant for her future retirement, are considered an asset. So unless she does some very fancy and expensive estate planning, or she cracks into the IRAs, pays the taxes, and blows it down below $2,000, this country won't help her. So it's the reality of what is. It's kind of unfortunate, and we try to help people as best as we can despite that. So we have SSI, totally disabled and indigent, SSDI, totally disabled, and worked and paid into the FICA system. Those are the 2 primary programs. There are some subsets of those, but we're going to just stick to those tonight unless you have questions. Let's go to next page. Now that we know what the programs are, let's talk about how Social Security actually thinks about them. What we've talked about so far is what they tell you in law school is black letter law, the main law. We're now going to dive deeper into the weeds, into what's called the regulations. See, in my little world of this little tiny niche practice of Social Security disability law, we have the law, we have the regulations, we have the HALEX, which reinterprets the regulations. We have the Social Security District Office guidelines, which reinterpret them again. And then we have Social Security rulings, which reinterpret them again. And then we have federal court decisions. So this is a really narrow area of law, but there's lots and lots of technicalities to it. Inside the regulations is an analytical framework that's used by every single decision maker, adjudicator, judge, appeals council, federal court. Everybody uses the same analytical framework when they review a Social Security disability application. They call it in their lingo the sequential evaluation procedure. Now, I hope by now you've gotten the idea that I'm not a typical lawyer. I'm a roofer's kid. I became a lawyer because I was so bad at roofing, they threw me out of the family business. Couldn't nail a nail in straight. I can only say sequential evaluation procedure twice in a day and my tongue goes on strike. I talk about climbing the ladder because that's how I grew up, with the ladders rattling in the back of my dad's Pontiac and a smell of hot tar, which is to me is still the greatest smell in the whole world. Let's climb the ladder. First, when anybody at Social Security picks up a file, before they even get on the ladder, they ask, is this a compassionate allowance case? Compassionate allowance came about a number of years ago from actually one of our rare good Social Security commissioners. And he looked at the program and he said, you know what? Some cases we just pay every single time. So if we pay them every single time, why are we putting people through all this nonsense? Let's make the assumption or presumption that people with this problem have such severe limitations that they could not function at a job. And they started out with about 50, and it's now about 260 different compassionate allowance conditions. Now, the bulk of them are diagnoses 17 letters long, and you'll never see them. They're rare conditions that doctors sometimes see. But there are a number of cancers that are considered compassionate allowance. It's on the next page. You see adrenal cancer, bladder and breast cancer, but with distant metastases, recurrent or unresectable, esophageal cancer, glioblastomas are on there. So if you have one of these types of conditions and you're applying for Social Security disability, before the pandemic, we would tell you to go to the local office and scream as loud as you can, compassionate allowance, and feet were supposed to come running, and your claim was supposed to be approved within 10 days. They never really hit the 10-day mark, but they did get greatly expedited. It's a little harder now because you can't get into the district office as easily, but when we file applications for clients that we believe may be compassionate allowance cases, we put big red letters and we try to flag it, and we call Social Security right away saying, please expedite this one. So if there is a compassionate allowance case, that should get awarded fairly quickly, assuming the other issues of work and FICA taxes for SSDI or financial resources for SSI are also met. If we have a condition that is not compassionate allowance, we go to the first step on the ladder, and that asks, is this person involved in substantial gainful activity? Make it easier. Is this person working? Make it easier. Is this person doing any full or part-time work, which is generating $1,550 gross in a month? That's SGA for this year. If you are, you're considered working, and your case is going to be denied at step one. Sometimes we can play games with medicine costs and things like that, but independent work expenses, but that doesn't happen very often. If you're working and making that much money, very unlikely you get past step one of the ladder. Assuming you're not working, go to step two of the ladder, which asks, does the evidence indicate that this person has a severe problem? Now, this is law, so words don't mean what they sound like. So in this case, severe means, is there evidence that this person is suffering from a problem that at least minimally impacts function? This step on the ladder is supposed to rule out things like hypertension or adult onset diabetes or sinusitis or conditions which are going to resolve very quickly. They're non-severe impairments. That is, they don't significantly impact work functioning, and those cases are denied at step two. Assuming you have a severe condition, let's use, I don't want to use cancer for this, but let's use fibromyalgia and depression, very common cases. Fibromyalgia is a chronic pain and fatigue causing condition, and depression is occurring because this person's life is so messed up by his diseases, and he's treating for it. We then go to step 3 on the ladder. Step 3 asks, does the evidence indicate that these symptoms meet or equal the listings of impairments? Now, the listings of impairments are in the regulations, and there's pages and pages and pages of them, and they cover all types of medical problems. There's listings for musculoskeletal problems. There's listings for cancer problems. There's listings for heart problems. There's listings for digestive problems. There's listings for mental illness issues. If you exactly match them, your benefits get paid, but they're hard to match. Cut my arm off, I do not meet the listings for being totally disabled for a musculoskeletal problem. Cut my leg and my arm off and I'm a double amputee, then I do. So this is a very high threshold. We've had over 60 clients in our office die, and Social Security said they didn't meet the listings, which is just hard to get your head around. But this is the first thing that we think about when a new client contacts us, because we know it's the first step on the ladder. I should go back here. It's the first step on the ladder where benefits can be awarded. However, while there are lots and lots of listings, there are none for fibromyalgia. There's a ruling, but not a listing, so you can't meet the listing for that condition. And the depression is bad, but he still takes his kids to school and he still goes to the park and he is able to interact with his family. And so while it's bad, they're going to call it moderate and not totally disabling. So we know he's impaired, but we know he's not totally disabled under a listing. We go to step 4. Step 4 says, what do we know? We know he's not working. We know he has a serious impairment. We know it's not so bad it meets the listings. What is his, remember the phrase from earlier, residual functional capacity, RFC? What do we think he can do? And does he retain the RFC to do any of the work he's done in the last 5 years? Now, if you saw the video from the last time I was here, I said 15, but Michael O'Malley and the Social Security Administration finally came to agree that in the last number of years, the job world has changed dramatically, and jobs that were present 15 years ago really aren't present today. So now they look at your past 5 years of work. If you retain the RFC to do that kind of work, now it doesn't mean you can get the job. What's your first name?
Peggy.
Peggy may have worked at steel mills, and those jobs are all in Korea. Or she may have worked in Zenith plant down in Melrose Park, and those jobs are all down in Mexico. Or she may have worked at the Hallmark store right across the street at Northbrook Court, and that lady says, oh my God, Peggy was so bad, I'd never have her back. That's not the test. The test is not whether Peggy could get any of that past relevant work. The test is whether I could prove she could not do it. If I cannot, we lose at step 4 on the ladder. If I can, we go to step 5. In step 5, what do we know? Our person isn't working. They have an impairment that impacts function. It's not so bad that it meets the listings. It is bad enough it prevents Peggy from doing her old work. Step 5 asks, okay, what is her residual functional capacity? And does she retain the ability, considering her age, education, and work history, to do any other types of jobs available in the national economy on a full-time basis? And that's when we get into the ticket taker to movie theater and coin changer to self-service gas station type job. If I can prove they cannot, I win. If I cannot do that, we lose. Every single disability case goes through that exact analysis at every level of the procedure. Do we want to take questions now? I mean, I'm happy to. Go ahead, I'll just repeat it.
They help you find a job that not just the hypothetical job that they say you would be able to do, but you may not be able to get that job? Like, would they help you get the type of job you could get if you're, you have that residual work capacity, where you could work?
So the question is, if Social Security does find that you have the residual functional capacity to perform work, will they help you find a job? And the answer is no. That's not what they do. This is strictly, you meet the test or you don't meet the test. They don't have pity on you. They don't feel bad for you. They don't care if you can't afford your food or put your kids in school. They're not going to care if you don't have a car. They don't care if your spouse divorces you. None of that is a factor. This is strictly, do you meet the test or do you not meet the test? Now, there's other agencies that can help you. Like in Illinois, we have the Department of Rehabilitation Services. But as far as Social Security is concerned, that's not a relevant factor. So we have the compassionate allowance list. Let's talk a little bit more detail about the listings for cancer. The very most common cancer call we get is breast cancer. And for many cases, we cannot help somebody that suffers from breast cancer because as medicine has evolved, the time from diagnosis to lumpectomy or mastectomy to chemotherapy and radiation to done with treatment is generally less than a year. And remember, we have to be totally disabled for a period that's lasted or expected to last a year or result in death in that time. So breast cancer cases in particular become really challenging for attorneys in this area of the law. Sometimes there's other issues that are concurrent, depression, lymphedema, things that may help us get benefits for this person. However, if the cancer has metastasized, moved beyond the regional lymph nodes, then that's a whole different type of issue to Social Security, and that's going to meet the requirements of the listings of impairments for cancer cases. They focus on the medical evidence of the site, nature of the tumor, the extent of involvement, response to treatment, pretty much what you would expect them to look at in your medical charts. That the only time this really turns into a big issue, or the main time, is the idea of permanency or lasting 12 months. Did you have a question?
No.
Oh, okay. Let's skip ahead. So the thing on this slide that I want you to remember is that Social Security is looking at function. They're looking at what you can or cannot do on a sustained basis, despite your medical problems. For those compassionate allowance conditions, they will stipulate that you cannot do full-time work on a sustained basis. If you do not have one of those conditions, you're going to go through the analysis we just talked about. Now, Lisa, I don't want to walk out of the, can you hand me that back? And sorry for people that are on Zoom. This isn't going to involve you too much. I'm going to need your help for just a second. I know that when I go through this, I learned years ago that I stress people out. And because we're talking about how hard it is to get these benefits. And it is hard to get these benefits. The vast bulk of people either denied or have to fight their way all the way through an administrative law judge hearing. And now I'm just going to talk about my practice. In my practice, we turn away about 70% of the people that contact us because they either have a technical issue like deeming, or we don't believe that their medical evidence is going to support that they can't work. But when we do take a case, we believe in that case, and we're going to fight really hard to try to get that person the benefits. But I don't want to totally stress everybody out so much. So we have these, and I'll let you pass them out. For the Zoom people, we provide stress balls for people to relax a little bit while I'm doing the rest of this talk.
Should have given those at the beginning. I was already stressed.
Well, I know there's a certain point. Good catch.
You need one too?
No, I'm good. I don't need more things distracting. So there are 3 keys to having a Social Security disability claim approved. And these are 3 major rules. Rule number one, you must be going to the doctor. You must be going to the doctor. You must be going to the doctor. When the pandemic came and we did all these kind of talks online, my wife, who works in my office, would hear me clapping and she'd know exactly where I was at in the presentation. These are medical cases. They turn only on medical evidence. What's your first name?
Lynn.
What Lynn says, and if we were in the office talking, I'd say, Lynn, what you say is not evidence because you want the money. As far as Social Security is concerned, you would testify under oath that I still had a full head of curly brown hair if that would get you $1,000 a month. What your mother, father, partner, best friend, priest say, none of that is evidence in your disability case that can help you get approved because they like you. The only thing that's evidence that a judge is going to focus upon are the clinical charts of the treating medical specialist. Now, this is actually not a bad thing because I want people to go to the doctor to try to get the help and try to improve. So I don't mind this, but you have to be going to the doctor. Rule number two, there's a right way and a wrong way to go to the doctor. Let's talk about that. And Lisa, do you mind if I pick on you? You can stay there. Do you mind if I pick on you? Though I did this once and got somebody upset, so I always ask permission first. So you all on Zoom can't see Lisa, but Lisa's a very nice person and she's got a very nice smile and she actually laughed at some of my jokes today. I told you all that I was a roofer's kid and my brothers and I were very lucky. We had wonderful, wonderful parents. They've been gone for many, many, many years, but I learned a lot from my parents. I still do. And a couple of things I learned from my dad. One of the things about my dad, he'd be up there on the roof and he was a klutz and I did inherit some of that klutziness from him. That's why I fell and hit my head when I left here for my other hypothetical. Well, he's working on the roof and whack, he hits his arm with the hatchet and puts a gash. Well, he's not going to stop the job. He wouldn't. The job had to get done. So he'd spit on it, put a glob of tar on it, he'd close it off. He'd finish the job and go home and my mom would see him and say, "Oi, Bobby, you did it again." That was my dad. He never complained. My dad never complained, no matter what life threw at him. My dad did not complain. He looked at it, he dealt with it, and he moved forward. The second thing about my dad, he was the world's biggest flirt. I mean, my dad flirted all the time. And I can't tell you how many times as kids, we'd be outside with my mom outside a restaurant, and she'd be puffing on those cigarettes that killed her at 58 and stomping her foot. She thought my dad was paying the cashier. He was playing with the cashier. It was harmless. It was my father. And I learned from him. I don't complain. I rarely complain. And I've learned to flirt pretty much like he did. First wife had an issue. Current wife understands me. Lisa, she's my psychiatrist. And she's got that nice smile. And today's my day for an appointment with Dr. Lisa. So what do I do today? I do the same thing every one of you all do. They going to see the doctor, I take a shower and I put on a clean shirt and I'll shave and I'll pat down what's left to be patted down. And just like you all, I'll walk into the office and Dr. Lisa will see me and say, "How are you today, Jeff?" And I'm going to say the same thing you all do every time. "I'm okay, Doc. How are you?" Now, you and the doc both know that you're okay relative to a really crummy baseline, but you don't start out the conversation by telling them that. What does she chart? Well-groomed, nice man says he's okay. She doesn't say okay relative to my really crappy baseline. Next month I come in. Now the clothes are a little disheveled and I haven't shaved for a couple of days. And I have this thing that they call in mental health a flat affect. I always think of the Monopoly iron when I read that, but it really means I look really sad. Doc Lisa says, "Jeff, I'm a little concerned about you. Maybe we need to adjust your medications." What do I hear? Adjust my medications. Now, I don't know how many of you all have dealt with people with mental health issues, but the last thing they want to hear is to have a medication change. I've been on Prozac. I've been on Zoloft. I've been on Wellbutrin. I like the Seroquel. I don't want to do this roller coaster of medication. Oh, no, Doc Lisa, really, it's just been a bad week. The dog pooped on the carpeting and the kid came back with a D on his report card. Really, there's no new symptoms. What does Dr. Lisa chart? Jeff says no new symptoms. Next month I come in, now I'm a mess. And I clearly haven't bathed or taken care of myself. My clothes are dirty and wrinkled. I've been growing a beard out that looks terrible. And she says, Jeff, I'm a little concerned about you. Are you sure things are stable? Maybe we need to talk about that day hospitalization program over at Lutheran General. What do I hear? Hospital. I've been in mental ward of hospitals several times, and they're not fun places. And I don't want to go back, not in any chance. No, Doc Lisa, really, I am stable. It was just another bad week. And I got in a fight with my kid's principal over something that happened at school. And the bill collector came to the door. Really, I'm stable. What does she chart? Jeff says he's stable. Every note gets read. What do they read? Jeff says he's stable. Jeff says no new symptoms. Jeff says he's okay. Okay, case denied, I lose. I've lost cases because my clients lie to their doctors. Now, I lied for really good reasons. I was trying to be nice. She's a nice lady. I didn't want my medicines changed. It's not unreasonable. I didn't want to go to the hospital. That's not unreasonable. But two things happen when you approach your doctor this way. Number one, you all know Dr. Lisa. She is an outstanding psychiatrist. But you also know that she's a really poor mind reader. And if I don't communicate, if I don't talk to her about what's going on in my life, she can't give me the best medical care. I'm not getting the advantage of how talented she is because I'm not telling her what she needs to hear. Second problem, her charts are inaccurate, and I'm going to get denied benefits that I'm really entitled to. The mantra that we teach our clients, every symptom, every visit, every doctor. I don't care if it's your OBGYN. You talk about your pain, or you talk about your fatigue, or you talk about your other problems, especially when they're asking what your history is. The rule is, if it's not in the chart, it doesn't exist. So you must talk to your doctors. What I teach my clients is talk about the person that you see in the mirror and just pretend you're following his life around and you're talking about his limitations and his frustrations. Number one, you'll get better medical care. And number two, your charts will be accurate. Third rule, Social Security likes specialists. Family doctors have a very limited role to play in disability cases. If you have fibromyalgia, they want you seeing a rheumatologist or a pain specialist. If you have a mental illness, they want you seeing a psychiatrist with a therapist or at least a good PhD psychologist. If you have cancer, it's the oncologist that's going to be the key doctor. Family doctors' notes will be looked at, but they're not going to be given as great a weight as the specialist. So Social Security really wants you treating with specialists in these cases. If you follow these rules, you'll be creating the evidence that we need in order to get you this help. We tell our clients, we're really good at arguing the evidence, but we can't create it. The evidence is created the moment you sit down with Doc Lisa. And if you can do that well, you'll get better medical care and we'll have the evidence we need to get you the help. So I put this slide in. I mentioned my grandkids before. My oldest one really liked that song, It's All About the Bass, About the Bass. Well, my world, it's all about the charts, the charts. The charts mean everything. Whoops. Okay, let's briefly walk through the different steps in a disability case. When somebody wants to try to get this benefit, the first step is to file an application. You can do that a number of ways. You can go to Social Security to do it. You can make a phone appointment to do it. You can do it online. Or what many people do is they hire a representative like our firm to do the application. And we have in our office 1.5 people whose only job is filing applications for people because doesn't happen right away. It takes a little bit of time to do. Once you complete that application, Social Security drops it because they have a contract. They have a contract in every state with a state agency to do the first 2 levels of review. And the people who do that in Illinois, they're down in Springfield, and they're called adjudicators hired by BDDS, the Bureau of Disability Determination Services. And their job is to review the application, send out questionnaires, get evidence from the doctors in the hospitals, and turn it over to an inside medical professional who you'll never see or talk to. I've never met one of these people. And they develop the RFC. And that's how the case is decided by an invisible doctor, may not even be the right specialist in Springfield, working under a contract with BDDS. Some people, they read the charts and say, this person can lift 50 pounds, denied. This person can stand or walk for 3 hours, denied. Oh, this person can't do anything. They're in bad shape. They can't function 8 hours a day. That person is approved. In Illinois, about 35% of the cases are approved at the first level. 65% are denied. The ones that are approved are usually pretty obvious. It's the double amputations, it's the brain stroke, it's the brain cancer or lung disease, any of the compassionate allowance cases. Assuming we're denied, we have 60 days to appeal, and you go to the second step called reconsideration. Reconsideration is initial application all over again, except done by another adjudicator. It's also backlogged, not quite as bad as the initial application level is, but they only pay about 10% of the cases at reconsideration. 90% are denied. Now, the ones that are paid is a case like a breast cancer case, because the woman comes to me when she's got breast cancer, it hasn't metastasized, she feels lousy, we think it may last 12 months, we file the application, but then it metastasizes while that application is pending. Oh my gosh, now it meets the listings, and the case gets approved at reconsideration level. Assuming that we lose at reconsideration, step 3 in the process is filing a request for a hearing before a Social Security administrative law judge. And this really is the most critical point in the process, because it is the only time that you get to see and talk to the decision maker. Everything up to this point has been done by phone, mail, and paper that they get from the doctors in the hospitals. Everything after this is done by written argument or telephone communication. But at the hearing, assuming you elect to do it either on Microsoft Teams or in person, you get to see the decision maker. And even if you do it on the phone, at least you get to talk to the decision maker. Administrative law judges are hired by the federal government. They are in a lot of different areas of the federal government, but the biggest number are in the Social Security disability process, and they go across the board. Some are really talented, and I'm very biased, so take it from my very biased viewpoint, are very empathetic and sympathetic individuals, and some are a lot more challenging. And you never know who you're going to get until you get the notice of hearing, and you have no control over that. But we win cases with every judge, we lose cases with every judge. The key is to have all of the medical evidence supporting this case in the judge's file, so that gives me something to argue. Then we work with our client before the hearing. We explain to them what the issues are going to be. We go over their questions. We make sure that they understand the process. The hearing goes ahead. And a little over 50% of the cases in front of administrative law judges are being approved. Now, this used to be significantly higher, but Social Security and the federal government have not really been looking to help the disabled population. They've been working to protect the integrity of the trust funds, and a lot of the rule changes have made it harder and harder to win cases. But anybody who does this for a living is generally winning more than 50% of their cases. But we screen and we educate and we work with our clients to make sure that happens. If we lose, and everybody who does this for a living loses cases, we get to file with the Appeals Council. They're in Falls Church, Virginia. You do not see them. You do not talk to them. It's strictly a written argument based on why you think the judge was wrong. They approve or support, or the word is affirm the judge about 92% of the time. So only a small percentage of Appeals Council cases are sent back for a new hearing, and even a smaller percentage are actually awarded. If we lose in front of the Appeals Council, we do have the right to file a lawsuit against the Commissioner of Social Security in the United States District Court. Our office does do that if we believe the case has merit. You do not get to testify. You do not get to see the federal court judge. What the federal court judge is going to do is review the testimony and the record and the opinions of the administrative law judge at your hearing. So that hearing is critical. It's the linchpin in the whole process. So you really want to have as strong a case as possible by the time you get to see the administrative law judge. These are the steps in every single disability case across the country. Okay, where am I at on time? Oh, all right, I'm pretty good on time. Let's switch gears for a moment. You went to the doctor, you documented your problems, we argued and advocated, and you're getting benefits. What's happening now? Everybody getting Social Security Disability Insurance or SSI benefits at some point is going to go through a continuing disability review. We're on page 17, right? These are very important to Congress, and I suspect with the new Congress, they're going to become even more important because they believe people should not be getting benefits for as long as they are getting them. So the test in a continuing disability review is there medical evidence of medical improvement sufficient to allow you to return to work? So, what's your name? Oh,
He doesn't talk, Keith.
Keith. I'm sorry, Keith. Thank you. So you all know Keith. He's been a client of mine, and he's a stubborn kind of guy, and I had to yell at him, go to the doctor, go to the doctor, go to the doctor. He went to the doctor. We won his case. He stopped. Now, he stopped because we weren't nudging him anymore. He stopped because the doctor said, I can't help you anymore. He stopped because the doctor moved away and he hasn't had time to find another doctor or whatever. About a year later, he gets notified by Social Security that they want to do a continuing disability review on him. And the first question they ask is, who's your doctor? Because we'll start with their medical charts to see if they document medical improvement. Well, Keith is going to reply, I haven't been to a doctor in about a year. And a big smile comes to the adjudicator's face who reads that answer. He says, no problem, I'm going to send Keith to one of my doctors. And I don't know how many of you ever sat through a Social Security consultative examination, but they're pretty embarrassing is probably a good word for it. It's basically get on the table, get off the table, walk heel to toe. How many fingers am I holding up? And name 3 past presidents. And if you can do that, they're going to find medical improvement and you're going to be terminated. So the rule for people getting SSDI or SSI, if you have family members or friends getting these benefits, they must be going to the doctor because the doctor will document the ongoing symptoms. And when their continuing disability review comes, you have a much greater chance of staying on the program. Let's go one step further. You're getting better. Doctor's doing a good job. You're communicating well. Your symptoms are going down. You know it's really hard to live on the amount of money you're getting from disability anyway. So you want to try to return to work. How do you return to work without screwing up your benefits? First, you have to know, are you getting SSDI or SSI? Because the rules are different. So we're going to start out with the rules for SSDI. And there's 3 benefits for people who want to go back to work on SSDI. The first benefit is called the trial work period. And it's really cool because you get to work and make however much money you can make, $2,000, $3,000, $4,000 a month if you have a decent job, and get your Social Security check each month. So cash flow is really good during this time. You're allowed 9 trial work period months under the Social Security Disability Insurance Program, but it does not mean 9 months in a row. What they define it as is 9 months in any 5-year slice of time. So let's take an example. I go on disability in 2015. I work 3 months in 2021, 3 months in 2023, 3 months in 2024. Between 2021 and 2024 is less than 60 months. I worked 9. I've used up my trial work period. I go on disability in 2015. I worked 3 months in 2016, 3 months in 2020, 3 months in 2024. By 2024, those months I worked in 2016 are outside of the 5-year slice of time. They fall off the table. They're not counted anymore. The purpose of going in this in detail is when somebody comes to Lisa at the Cancer Wellness Center and says, I'm on SSDI, how many months can I go into my trial work period and still get my benefits? Her answer is always going to be, I don't know. Because she doesn't know how many months you worked last year or 2 years ago or 4 years ago. And we go 60 months and counting what your trial work period is. Now, to make it a little trickier, the definition of work for this purpose is different. For this purpose, any full or part-time work generating $1,160 in a month is a trial work period month. Last year, this year, 2024, it's 1110. Last year was, I believe, 970. It changes every year with the cost of living. Another reason why when you go to Lisa and ask that question, she's going to tell you to call Social Security and find out how many months they show you've used up of your trial work period if you have done some work in the past. But 9 months with a ongoing chronic, totally disabling condition doesn't really tell you very much. And Social Security recognizes that. So they have a second benefit. The second benefit on SSDI is called the extended period of eligibility. Now that says you've been on disability, you've worked 9 months, but we know you're still at a very high risk of having severe issues. So for the next 36 months, if you're making at least $1,620 next year, $1,550 this year a month, we're not going to give you a check. But if any time in the next 36 months you fall below $1,620 gross in a month, we'll resume benefits. You're right back on the program. No more questions asked. This is a really important benefit because it doesn't matter if you fall under that number because your condition worsens. It may be because you develop a new condition. It could be because the lady closed the Hallmark store and you're out of a job. If you're not making $1,620 gross in a month and you haven't been cut off by a continuing disability review, right back on the program, no questions asked. There's a third benefit to going back to work on SSDI, and that's Medicare insurance. Remember I told you get that federal red, white, and blue card? No matter what anybody says, nobody wants to give up their Medicare. So this was especially important before the Affordable Care Act, which took away the issue of pre-existing conditions, but may be important again because we don't know in the new Congress if the Affordable Care Act will survive or not. What you do under SSDI, you keep your Medicare for the whole 9-month trial work period. You keep your Medicare for the whole 3-year extended period of disability, and you can keep your Medicare another 4.5 years after that. So you can keep Medicare insurance for over 8 years when you return to work on SSDI, and you don't have to worry about getting health insurance or treatment for your medical problem. So 3 benefits going back to work on SSDI. Let's talk about SSI. Remember, SSI is means tested, assets, income, $2,000, no money coming in. So now this becomes a math formula. And the way it works on SSI, when you return to work, they ignore the first $85. $20 for one reason, $65 for another. Honestly, I don't remember what they are. These numbers have not changed since 1979, although there have been repeated requests. I'm sorry, 1979, although there have been repeated requests to increase this. So $85 is ignored. Then they reduce your SSI check by $1 for every 2 that you earn. So let's pretend I'm on SSI and I'm getting this year $974 a month, and I go do some Mary Kay sales. And I sell $285 in Mary Kay products. They ignore the first 85, that's off to the side. $200 remaining. They reduce my SSI check by $1 for every 2. So $100 will be taken off my next month SSI check. I'll only get $874. But when you do the math, $874 and $285 is still way better than $974. Plus I'm doing something, plus I'm being productive, plus I'm interacting with the world. So we always try to encourage people to go back to work. It's just a better way of life than being on SSI or SSDI if they can. Here's the key with going back to work. You must notify Social Security. In fact, you notify Social Security for any major life changes. If you go to work, if you get married, if you move. Now, how do you do that? Well, you can call Social Security's 1-800 number and you'll talk to a very, very lovely Mrs. Smith. You'll even hear Mrs. Smith typing in your information. Is she typing in your information or is she writing a letter to her sister? You'll never know, and you can't prove a phone call. You can mail it. How do you know they got it? The best way to report, if you're on SSI, is an app. It's called Social Security's Mobile Wage Reporting application on your phone. Each month you go in there, you tell them how much you earned on while you were getting your SSI, you get a receipt, they'll adjust your next month's check, and you don't have a problem. On SSDI, the best way to report is, again, off your computer, laptop, or phone. Go to Social Security's website at ssa.gov, open up your My Social Security account, and report there. If any of you have not yet opened up a My Social Security account at ssa.gov, I want you to do it tonight or tomorrow. It's really important. Where you get to check your earnings record. Some of you may remember when we used to get our earnings records in the mail, and it told us how much we get for retirement or disability or survivors and how much we've earned every year. Now you get that offline at ssa.gov. It's also a good source of information. So it is a good thing to go to Social Security's website and open up a My Social Security account. You need to report to avoid overpayments. Overpayments are awful. They're stressful. Generally, they're very hard to work with Social Security on. So please, if you do go back to work, and it's wonderful if you do, make sure every month you report your gross earnings to Social Security. All right, I'm pretty good on my time tonight. That's unusual for me. But I want to thank Lisa and Savina for putting this together. There's a lot of work putting on these kind of programs, and they do it regularly, and they're very efficient. They're very pleasant. They stayed on top of me with this. And I really thank them for the work they do. And I think the Cancer Wellness Center, this is a place that makes a difference. People need support. People need safe places. People need people to talk to. And the Cancer Wellness Center does that. And I've sent a number of my clients here, and I really appreciate everything they do. And for everybody, this is the year end when all agencies are in that process of looking for year end help. So if you can help here, I think that would be a good thing. My website, rkblegal.com. I do wear 2 hats. In addition to this job running this law firm and representing people, I'm also the executive director of the National Alliance on Mental Illness, Cook County North Suburban Chapter, NAMI CCNS. Very proud of the work that we do there. And that's kind of been a long in my career, second opportunity to make a difference, and I really enjoy that. I used to be on the board of NAMI DuPage. I've also been on the board of the Alliance to End Homelessness in suburban Cook County. I've been blessed to have a lot of friends and be able to help out, and that's just made it a good career so far for me. There's our contact information. You don't have to hire us to ask questions. Almost every Social Security lawyer will take phone calls and answer basic questions. In my office, you'll usually talk with Kelly, who's our intake director. So if you have questions or something doesn't make sense, you can go to our website and fill out a form, or you can give the office a call. And if you mention that you're from here, we'll make sure you get taken care of. On the side there, we have our bags. Sorry, Zoom people. And business cards and brochures, whatever you may need. All right, I've talked a lot. Are there questions online? Are there questions here?
I have a couple questions online. One of them is, so what if you qualify under compassionate allowance, but continue working until you can't physically work anymore, but do qualify?
You don't qualify under compassionate allowance if you're engaged in substantial gainful activity, which this year is $1,550 gross in a month. 2025 is $1,620. You're not totally disabled if you're working.
And then if you are approved for compassionate allowance, do you still have to go through the continuing disability reviews?
So every case is coded by Social Security when they expect medical improvement, and you never know how your case is coded. So the answer is it'll depend on the condition. I mean, somebody with severe Alzheimer's is not going to get reviewed. Somebody who has lung cancer, who may be successfully treated in rehab, very likely to get reviewed.
Yeah, let's say like metastatic breast cancer, that's not common.
They're very likely to get reviewed because it is treatable. Now, you know, the Social Security, sometimes they just do an internal paper check and you don't even know you've been reviewed. Other times you get that letter that says, okay, you need to update us on your medical information because we want to see how you're really functioning.
All right, two more. Can you qualify for Medicare due to disability, even if you're not applying for supplemental income or other monthly payments? Do you have a work history? I'm asking about someone who hasn't worked.
All right, so there's a couple of issues there. So let me try to sort that out. You can get Medicare at age 65. You can get Medicare if you're totally disabled for 29 months, and you will get the cash benefit. If you don't want it, put it in the bank for the kids or donate it to the Cancer Wellness Center. That's perfectly fine. If you've not worked and paid into the system, though, you can't get Medicare if you're on SSI. SSI will give you Medicaid, which is often good enough. Again, Medicaid and Medicare are both on the chopping blocks with this upcoming Congress, so we don't know what will happen. But you do get Medicaid if you're on SSI. You also get Medicaid in Illinois because we do have the expanded Medicaid program under the Affordable Care Act. Our governors were wise enough, and again, I'm being biased, were wise enough to adopt that. Not every state has chosen that path. We do a lot of work in Tennessee. We have a lawyer who works for us who lives in Tennessee. They've not chosen expanded Medicaid, and their people really suffer trying to find any kind of health care at all.
And last question, when you talk about medical records and charts, does mental health professionals count? So if somebody were to come to the Cancer Wellness Center or a local therapist, do those notes, are they considered part of the case, or they're HIPAA and they don't apply?
First of all, when you go and file for benefits, you're waiving your HIPAA rights. You sign a medical release for Social Security. We actually have 2 or 3 versions of medical releases signed for us. Mental health therapists are key. I mean, they are sometimes the difference between winning and losing a case. And why is that? Well, Lisa, the psychiatrist, the way medicine has gone, many psychiatrists are just doing medication management. Are you homicidal? Are you suicidal? How's your sleep? And here's your pills. They're not asking how you're functioning. How are you able to get along with people? How's your concentration? How's your ability to adapt in a work setting? That's what the therapist does. So especially in non-mental health cases, mental health is still a factor. So my clients with cancer, my clients with fibromyalgia, with long-term chronic pain problems, almost always have a depression aspect after a while to their life. And we encourage them to treat with the psychiatrist for medication and then the therapist for the counseling and the support. And then we also are generating evidence of how poorly people are functioning. And that's something we can then argue to the judge. Any other questions? Again, thank you guys for putting this all together. Thank you all for coming out. I hope people on Zoom were enjoying their dinner while we were talking. And then you can always reach out to us if you have any questions. You can email me, you can go on our website. We're more than happy to try to help you out. Thank you.
Any other questions? Good job.
That was okay.
Thank you. Sorry, just quick question. Did multiple myeloma qualify under compassionate allowance?
Ooh,
It was
ooh,
not.
tough one. I don't think so. Let me go to that page real quick to see if it's on there. But I don't think it is because we get questions with that, and some of those cases are actually challenging. No, generally, I don't think multiple myeloma is a compassionate allowance. There is a listing for it, but it is not automatically approved. But to be certain, if you just Google compassionate allowance list Social Security, it's going to pop right up on your screen and you'll see.
What happens if you have not reported income? That's a question that I received online.
So you heard me say I'd worked for cash and never paid the man a dime. If you don't pay the premiums, you don't get the benefits. So you won't have qualified for SSDI. If you stop working altogether because of your medical problems and you're indigent, you may qualify still for SSI. But not paying FICA and your employment taxes, and if you're self-employed, paying it quarterly, really is a bad idea because this insurance is vital. Remember, over 70 million Americans are getting benefits every month from Social Security. Most are retirement, some are disability, some are survivors. But this insurance program is really vital to people. And knowing that you have at least a minimal financial safety net available in this country for death and disability and for when you hit retirement age is really critical. And what, working with this system, you're going to appreciate, even if you get mad at the team, the staff over there, how important the work is that they really do.
Thank you. Thank you everyone on Zoom and thanks